This is the fourth video in our series on the impact of consumer law on digital products. We looked at an overview in the first video, and in the second and third videos we looked at how you form a contract online and how consumer law impacts that. In this fourth video, we're going to look at some of the regulatory hot topics in the consumer space and the online contracting model. First thing I want to look at is the freemium model for apps. This is an incredibly successful and popular commercial model for app distribution. However, in recent times, consumer regulators have taken a close look at this because they're concerned that consumers are being misled about the fact that some of these apps require purchases in order for them to be fully enjoyed. So if you're releasing an app on a freemium model, it's quite key that you're clear to the consumer about what's free and what it is they need to pay for. And even more important, if they do need to pay for things in the app, what that means for their enjoyment of the product. So consumer regulators in the US and Europe have both recently issued guidelines looking at freemium models and requiring things such as the range of in-app purchase prices to be disclosed at the point of purchase. They're also requiring you to take a look at whether purchases are required for certain functionality. So let me take an example. It would be okay if an app was totally free to call it free. But if you couldn't get past level 3 without purchasing something, then you'd have to disclose that at the outset, and you probably wouldn't and shouldn't call that app free. The other thing you need to look at is when you look at the in-app purchases themselves, how do we convey that information to the consumer inside the app? It needs to be clear that they need to make a decision. It needs to be clear that they're buying something. And because of rules around fairness of commercial conduct, you'd want to think hard about trying to make it an emergency purchase situation so the consumer doesn't have time to make an informed choice as to whether or not they want to buy, if they want to keep their points, keep their level, keep their life in the game or the app. The third thing to think about in the context of freemium models is the misleading use of the word free. Now, I've already touched on this when talking about some of the things you'd want to expect to disclose to consumers, but there is a lot of scrutiny in the consumer world and consumer regulation world around using free in a way that is transparent and clear. The second hot topic worth thinking about is child protection. If the product you're building is targeted at children or has a reasonable expectation that children will use it, there are rules that may apply. There's three things to think about here. The first is content ratings. Are there any rules around films, music, games that require you to apply a rating to a product? In this context, you need to not just think of one jurisdiction. Different countries have different rating rules, and the products need to be sophisticated enough to apply the different ratings that apply no matter where your consumer is. Second, content gating. So is there a requirement to build your product with certain parental controls or with certain limits on when or to whom content is available to try and stop children having access to it? And third, in-app exhortations to buy. Lots of consumer laws have restrictions on encouraging children to make purchases and what's often called pester power, encouraging children to pester their parents to make purchases. When you have a children's app and you make offers to buy certain in-app purchases in the app, those rules can often be touched, and the regulators are looking at that closely at the moment. And third, the hot topic you should always have in mind across all digital products is data protection. It's not really part of consumer law, but it is similar in that it's a protective jurisdiction designed to look after the interests of consumers. Just a couple issues to flag here, won't go into them in detail. First, general data protection rules about making sure consumers know what data is being collected and what you're going to do with it. We're seeing a recent trend for more and more of that information to go from the privacy policy into the actual process flow when somebody's signing up for a service. And second, geolocation data. There's a great value in collecting geolocation data, and the commercial opportunities of it are still being worked through and developed. But lots of jurisdictions have specific laws around collecting that data, and it's a particularly sensitive topic for regulators, knowing where people are. So if your product does collect geolocation data, you'd want to make very clear, firstly, that the consumer knows that you're collecting it, knows what you're going to do with it, and also that you're complying with local rules around that collection.